Okay, welcome to the Advisor's Responsibility Dealing with Vulnerable Clients webinar. My name is Marshall Beyer, Senior Director at CSI, a Moody's Analytics company. I am very pleased to welcome you to this webinar. Advisor's Responsibility Dealing with Vulnerable Clients to be presented by Sean Shore. Today is World Elder Abuse Awareness Day, which is why we picked this day to hold this webinar. It is a day that serves as a call to action to bring attention to the issue of elder abuse, often also tied to cognitive decline. Today's webinar is being recorded. The ratings, financial reporting analysis, projections, and other observations constituting part of the information contained herein are and must be construed solely as statements of opinion and not statements of fact or recommendations to purchase, sell, or hold any securities. We ask that no one record this webinar without Moody's explicit written permission. Lastly, no one has permission to quote any of the comments made or questions asked by the webinar audience. Please note that the following presentation is being offered by Moody's Analytics, which operates independently of Moody's Investor Services, the credit rating agency. For optimal listening, all attendees are currently muted. If you would like to ask a question, please enter it in the Q&A box in the lower right corner of the webinar presentation screen. Note also that there are no continuing education credits available with this webinar. So why this topic? As individuals progressively live longer lives, advisors will need to be more mindful of specific financial advice and strategies around or associated with aging. Fundamentally, this will require advisor strategy as a result of living longer and tools to protect them from the challenges that may arise, such as reduced or diminished capacity or financial exploitation by others. Securities regulators in Canada and in the United States have identified vulnerable clients and the importance of supporting vulnerable clients as a key issue that participants in the financial services industry, both firms and individual registrants, must be aware of in their day-to-day operation and practice. We are very fortunate to have Sean Shore with us to provide guidance on this important issue. Sean is a graduate of the University of Manitoba's Faculty of Law and the London School of Economics, and is a lawyer with Canadian compliance and regulatory law, where he has worked since 2014. Operations that are registered in the Canadian investment industry. As part of that role, he has worked and consulted with regulators and dealers in the area of vulnerable clients. Note that CSI will be releasing its series of courses covering client-focused reforms shortly, of which protecting aging and vulnerable clients is one. So without further delay, here is Sean Shore. Sean?
Thank you very much, Marshall. That was a very kind introduction. And as you've said, this is today is World Elder Abuse Awareness Day, and it's fitting that we're talking about this issue today. It's a really great issue for advisors and all registrants, both advisors and in the compliance department. It's a way for us, obviously, to return value and thanks to our clients, our most important resource, but it's also a way that we protect our clients, support and lend integrity to the capital markets, and of course, bring forward support for investor protection generally. So with that as background, and I've personally received probably half a dozen emails from regulators this morning reminding us that it's World Elder Abuse Awareness Day and how important it is for us to detect red flags and so on. So we're going to be speaking about a lot of stuff today. I think it's going to be a very, it's a lot of fun to have this issue before us, and I'm looking forward to all of the questions that that might come forward. So with that, we can move forward to the next slide. There we go. Thank you. So we'll just have a warm up here. This is a good case study. So we have a registrant, an elderly couple are their clients, been clients for many, many years, 2 decades, more than 2 decades. Health of one of the spouses is deteriorating. The assistant of the registrant is named power of attorney. Okay, so problem number 1. The spouse passes away. We have a surviving spouse that becomes more heavily reliant on the registrant and the assistant. The surviving spouse then names the registrant and assistant as majority beneficiaries in their last will and testament. Next slide, please. So as much as you think that this doesn't happen, it does happen, and it's happening all the time. And as registrants, it's so important for us to be aware of these types of fact patterns. So this is an actual case from IROC. I've listed the site there. Just so happens that the surviving spouse also provided cash gifts to children of the registrant and the assistant. The assistant, of course, as we know, is the spouse of the registrant. So here's a pro tip that you might chuckle of. Despite your desire to help your clients, and this is something that I speak to our clients about all the time, resist the temptation to become an executor. Really resist that. Same thing for a power of attorney. We have rules in the IROC world about becoming a power of attorney anyway, or becoming having influence over clients' affairs. And whatever you do, if you become aware of it, don't ever agree to become a beneficiary. And again, as much as you think this is impossible, this does happen very regularly, sometimes for nefarious reasons, other times not. And then in another instance that I'm aware of, a registrant actually decided to retire from the practice, from the industry, after learning that they had become a beneficiary, which had nothing to do with them. So when in doubt, and I'll keep going back to this, contact your compliance department, and we'll go to the next slide, please. So here's our agenda for today. We're going to have a bit of a background and introduction to the issue. We're going to talk about detecting and preventing financial exploitation of your clients. Have a quick discussion about the historical, current, and future regulatory expectations. We're going to talk about, and this is what sort of brought this issue forward, I think, the new rules that are coming online about trusted contact persons and temporary holds. Probably familiar with those, and as well, I'm going to end with, by protecting your clients, you are protecting yourself, and this is both protecting yourself in the context of what regulators expect of you, but also you're protecting your book of business. And I do think that's a really relevant issue to the advisors who are tuning in today, to understand that, like everything else in compliance, this is about protecting your most valuable asset, which is your book of business. So we'll talk about that a little bit later. Can we have the next slide, please? So what's the problem, and really why do we care about this? Well, we have an aging demographic. You heard the introduction from Marshall. You have an aging demographic, which is arguably becoming the largest segment of our society. This demographic possesses an enormous amount of wealth. The demographic is living longer, and they're also requiring more needs to live longer, to live better, and to have the life that they've worked so hard, and to enjoy that lifestyle longer. Subsequent demographics, their kids, grandkids, they're perhaps less fortunate. They may not have had as an easy a life, and in some instances have certain expectations. And that is really where I will focus the attention of advisors who want to talk about succession planning of their book of business, as well as protecting themselves against that next generation. Next slide, please. So really, why do I care? Well, as registrants, we are in very close proximity to our clients. And in doing so, we're providing wealth care and maintaining their financial health. When we do take our role seriously, we really have to know our client. And that is the key here. So I'll be talking about getting back to basics, and what are the basics of our job? Know your client, know your product, suitability. So these are the basics. And when we take our role seriously and know our client, the issue of elder abuse, the issue of vulnerable clients becomes much easier. So arguably, we have this role, and sometimes we may even know more than family members do. So this becomes critical for us to detect change. If we have a relationship, it's been multi-years already, we'll have a good idea of whether or not Sean is feeling a bit off today. It's strange. I had a conversation with my client. He seemed a bit off today. And more so than ever, financial crimes are more prevalent, both in number and sophistication, especially in cybersecurity. Next slide, please. So here's a reason, if you don't think it's important for what I've already said, well, the regulators are telling us it's extremely important to them, and therefore it should be extremely important to us. So this just came out a couple of weeks ago. I saw that release, and I wanted to include it in the slide deck. Go ahead, please. Next slide. So what role do we play in someone's life? Well, vulnerability creates heightened reliance. And like other professionals, in some instances, we become fiduciaries. That's a question of fact. As there's more reliance placed on you by clients, it becomes more likely that you may become a fiduciary. Less so for providing advice, but more so clients are relying on you as someone that they trust. And really, I cannot underscore that that is really the case. So our role is as much about giving them good investment advice. It's about giving them and making them feel like they're protected. And we are really the first line of defense here. And when advisors speak to me about how they can detect red flags, and well, I'm not really a psychiatrist, and I'm not really, I don't know if I can understand cognitive issues. This is really a simple conversation. This is, you are in the relationship business. And when you know someone, you know when they're on their game, and you know when they're off their game or when they're not feeling well. And that's the key. Next slide, please. So here are some thoughts from an older notice. I'm not going to read it to you, but here's what the CSA is thinking. And part of that talks about what vulnerability is. And I would highlight the fact that vulnerability is not about being a certain age. Vulnerability can be from addiction, it can be from mental illness, it can be from a variety of things. So we have to keep that in mind, that this isn't just an issue restricted to our older clients. And the flip side of that conversation is we have to be aware of being of potentially discriminating against our client, of assuming that because a client is a certain age, they're incapable of understanding a particular transaction, or they're incapable of taking risk. And I've been told very bluntly by some clients who are in their 90s, who have been trading options contracts for 50 years, that they can very much take care of themselves. Thank you very much. So this is a slide that you should review and keep in mind. Next slide, please. So I'm going to talk about this quite a bit. You're going to get sick of this. This is so important. We see this all the time. It never gets old. And you really do, registrants really do need to take to heart the idea that your responsibility, in addition to what we've spoken about already, know your client, know your product suitability, take notes, document your file. This is very, very important. And time again, when dealing with complaint handling matters or litigation, we see the notes or the file that's been maintained by a client, by an advisor, to be in very, very poor condition. And this is just something that really will come back to haunt you, especially with this particular issue. Next slide, please. So we talked about vulnerability. This isn't just about clients who are sick or infirm or incompetent, does not discriminate based on age or severity. And this is going to include disabilities, illnesses, and I want you to start thinking about cognitive impairment. So don't be fooled that this is a seniors issue. Age is not relevant at all necessarily. Next slide, please. Another important concept, and this is sort of me wearing my lawyer hat. This is about competency. So whether from issues relating to diminished capacity or exploitation, this is critical for us to consider. So clients need to have capacity when they're giving us instructions. Think about when you go to the doctor, you're having a surgical procedure. They shove a form in front of your face and say, sign this. If you don't sign it, technically the doctor could be assaulting you if you don't sign it. You're giving him your consent, him or her your consent to perform the procedure. We need the consent of the clients. They need to be competent. They need to understand the instructions that we're giving them so that they can confirm those back to us. This is extremely important. Without that, this becomes problematic because perhaps we didn't have the instructions to proceed with a particular transaction. This goes a lot to age, but it also goes to cognitive ability, which can strike anyone. Next slide, please. So these are the definitions that are referenced in the current proposals that are in 31103. So they talk about diminished capacity. I'm not going to read these. They talk about financial exploitation. And these are the things that we're going to be referring back to time and time again throughout these slides. Next slide, please. I think we have two more on the next slide. And then we have mental capacity and vulnerable clients. So this relates to vulnerable clients, relates to illness, impairment, disability, or an aging process, which creates financial exploitation. And these are the types of things that when you're approaching and having conversations with clients, I would encourage you to take a very liberal approach to to these concepts. It is not a bad thing for you to be critical of whether or not a particular client in a particular set of circumstances is not all there or is having issues, or you've detected a red flag or what have you. So these are the guideposts that the regulators have established in the current version of 31103. It's a good read, especially the companion policy, which we'll reference down below. But these are the things, these are the concepts that we have to become familiar with as we approach these issues. Next slide. Okay, so here's another case study, and I want you to consider the idea of financial exploitation. An employee happens to be your client. An employee receives an email from their boss. Boss says, "I need you to buy some Google Play gift cards." The employee does so, gets another email back, "I need you to buy more of them, and if you don't, I'm going to embarrass you." Cognition, mental illness, this isn't just where it's limited to. When someone is under undue influence, which oftentimes happens with individuals who are older, this can also create vulnerability. Do not underestimate it. The fact pattern that I'm giving you really has nothing to do with with a client and their investment accounts. It has to do with somebody being under the undue influence of others. If you detect this, if you think someone is in the background telling a client to do certain things, you really need to act on it. Next slide, please. So compliance people love red flags. So given our role and given your role, usually you will be the first person to detect a warning sign or a red flag. And this assumes that we know our clients in the first place. So take the time during the client discovery process to know your client. The best time to know your client is now. So if you haven't done it, if you feel that you haven't done a good enough job, the best time to start knowing your client and building that relationship is now. Usually that takes place during the client discovery process. Build that foundation, have those meaningful discussions, and you will see that you will be rewarded at the time when the client needs you the most, which is when they're most vulnerable. So this baseline understanding of your relationship with the client and their mannerisms, how they speak, how they instruct you, and so on, that will allow you to see the changes when they happen. Next slide. So here are some current red flags. These are all part of the regulatory guidance that you can review. Sudden changes in lifestyle or interests, change in know your client information. So if you know your client, you've papered the account already, they come in and say, "I want to change everything. I want to take 10 times the amount of risk that I've taken thus far," with no other change in facts. So they're still, say, making a certain amount of money per year, and yet they want to increase the risk. Okay, what does that mean? Where is this coming from? Ask those questions. Unusual requests to transfer assets resulting in a change of ownership. This is a big one. So if you see transactions or requests for transactions to move money in or out of the accounts, I'd be asking questions as to why. Also, your dealer or your firm is also going to have policies and procedures dealing with third-party transactions. So again, contact your compliance department if you're not certain of what's happening. If the client is reluctant to discuss financial matters, if there's sudden changes in legal or financial documentation, and if new individuals are all of a sudden inserting themselves into clients' lives. Now, we've just had, and we're hopefully near the tail end of COVID, but COVID has brought another set of facts to this discussion that you can have clients who are getting ill from this terrible disease and being in the care of physicians for quite some time. So pay attention to these sorts of details, these sorts of changes. Very, very important. Next slide. Other red flags, and we'll talk about powers of attorney quite a bit. If you have an account that's subject to a power of attorney, you'll already know that's the case. It's been documented. Expenses are no longer being paid. There are unusual charges coming out of the account. There's changes to the client's care. There's changes to the client's power of attorney documentation. You have challenges contacting the power of attorney, or there's a new power of attorney. Next slide, please. And I think I'm going to spend some time on powers of attorney here. So this area, we answer a lot of questions on powers of attorney, and it's sort of an endless conversation. Have baseline documentation available at account opening. Even if your client is very young, I'd be asking the question to a 25-year-old, do you have a will? Do you have a power of attorney? If you do, I want to have a copy of it. It's very, very important to have that on file. Now, this is a question that we get all the time. Are old powers of attorney invalid? And the answer is no. You obviously have to check them. You have to have other conversations with your clients. But the fact that a power of attorney shows up on your desk that's 20 years old doesn't make it invalid. Know the difference. There are different types of powers of attorney. Some are enduring, which means they survive mental illness. Others are all of them will survive mental illness, but some of them are automatically in place right now. They're live once they're signed. Others are springing, which means an event has to happen. The client has to become incompetent, and that incompetence has to be validated by physicians in order for the power of attorney document to become valid. Educate your clients, know the law by jurisdiction, because this is a provincial matter. And of course, gifts. We talk about this of gifts all the time. Powers of attorney usually cannot give gifts by virtue of the power of attorney. They can't change beneficiary designations. That's another important one. Check with your compliance department on that and know the law in your jurisdiction. Next slide, please. So on diminished capacity, here are some red flags. Your client has memory loss, difficulties understanding basic concepts that they clearly understood before. If they have difficulty communicating with you, changes in their personality, if you're detecting general concerns with their competence, if they're confused, if they're showing up to meetings disoriented or perhaps looking not the way they would normally look, if they're usually well kept, if they're not well kept, these are red flags to consider. Next slide, please. There we go. Thank you. And so now you have these red flags. What do we do now? Well, as we've talked about, know your compliance department, be friends with those people in the legal department, and escalate this to either your branch manager or the compliance department immediately. If you have a concern, I really will not be upset with you if I get a call from an advisor and it's an advisor potentially being exuberant here when in fact there's nothing to be concerned about. Very, very important to not be shy if you are concerned about this. So some steps to consider: you may want to contact the client if you've detected certain changes that are concerning to you. Contact the power of attorney, contact the trusted contact person, which we'll get to in a second. We will talk about account freezes or holds. And if all of that is really in play as well, other things to consider are contacting local law enforcement or the public trustee or public guardian in your province. Next slide, please. So here's another case study. A client seeks an unusually large cash withdrawal, not in keeping with previous transactions. There's no explanation. What do? Do you carry out the transaction or do you hold? Again, your firm policy is going to guide you in terms of what you can and can't do here. And I always say, and this is an approach we've been taking for quite some time, probably over 10 years, is that if the money is still there, will I really get in trouble? So in other words, if I tap the brakes on this transaction because I'm a little bit nervous and there's really no explanation, I'm not getting the warm feeling that I need to get to ensure that the client is all there. Tap the brakes. The money's still going to be there. Contact your compliance department, contact the legal department, and get them involved to make sure that this is legitimate. Next slide, please. And just as a background to that previous one, we often will have clients, in particular elderly clients, who contact their financial institution saying, I need to withdraw an unusually large amount of money. Ask them what it's for. Are they going to buy Bitcoin? Because oftentimes scams that we hear about and read about in the news are instructing these clients to go and acquire cryptocurrency in order to pay off certain things that may in fact be completely false for the client. So on this slide, we have our regulatory discussion. So the CSA, the Canadian Securities Administrators, IROC, and the MFDA have all issued guidance and announced their expectations. It's very similar. Everyone has a seniors and vulnerable clients page, and this issue really touches everything. So we really have to be, and it's very topical given that we have client-focused reforms on everybody's mind these days. The issue speaks to know your client, know your product, suitability, marketing, how we advertise to clients, the language that we use, titles. Titles is going to be a sleeper issue for the industry, especially titles that reflect a certain proficiency that may impact vulnerable clients, like I'm a retirement specialist, supervision and complaint handling, and of course, escalation and of course, training. Next slide, please. So here's a reference. We spoke of this before. 31.354. These are the suggested practices for engaging with older or vulnerable clients. This talks about red flags, know your client suitability, complaint handling, supervision, and so on. It's a great read. I encourage you to get through that and educate yourself on it. It's really one of the starting documents that sets out the issues and how important this is for everybody. Next slide, please. IROC has issued similar guidance in 2016. They broached the subject of trusted contact person as well. Later on in future guidance, the concept of hold periods were also introduced by IROC. So again, we have a similar approach from IROC, and the next slide, I believe, is the MFDA as well. There it is. We can go to the next slide, please. Okay, so here are the key concepts that we can talk about. Given proximity to clients, registrants are going to be the first people to observe or detect these issues, in particular relating to mental capacity and financial exploitation. Our understanding of the red flags that might motivate us to this conclusion is going to be detected as a variance to our baseline or the client's baseline behavior. And what I think is important is for us to adopt an enhanced approach to know your client information that is focused on certain issues, focused on the client. So for example, intended retirement date, expenses in retirement, liquidity needs, gathering the POA information and the last will and testament information, and keep all this information current. Next slide, please. We have to adopt an enhanced approach to suitability. So for example, if you have clients that are elderly, it may not be a good idea to be saddling them with products that have a very long or an unusually long time horizon or are overly complex. Now, at the same time, the fact that a client is older doesn't negate that a particular product is suitable, but it's a conversation and it's a discussion, and there's some analysis that has to happen each time. Complaint handling procedures should not be complicated for vulnerable clients. The process should be easy, and and we know that most registrants will have that process publicly available on their websites. And also on the supervision side, conducting heightened supervision with a focus on reviews that speak to age-based criteria. However, again, we have to be concerned with discrimination issues, preventing people, say, for example, who are over the age of 65 or 60 or 70, whatever the number is, from investing in particular securities, or the assumption that they can't take on certain degrees of risk. Again, this is the conversation about knowing your client and understanding what the client wants, their retirement needs, and so on. Next slide, please. So identify the accounts that have active powers of attorney, and that will help with supervision. Oops, there we go. Training to equip our registrants to detect red flags, gathering information on the trusted contact person who is not the power of attorney, escalation, and of course, communicating with vulnerable clients in plain language. Next slide. So now we'll have a brief conversation about client-focused reforms. So we're not going to talk about client-focused reforms today other than to mention them, because I think we're all very busy discussing client-focused reforms outside of this webinar. However, all of the above issues, I shouldn't have said anything to you that strikes you as novel. You should be saying, well, I do all of this already, Sean. And if so, that's great. So get back to basics, know your product, know your client, and suitability, and just document everything. And I keep saying document everything because I want you to change your focus to not just include who your client is as the current client, but think about having a conversation with the next generation, the children of those clients, the grandchildren of those clients, who hopefully will become your clients when we have this transfer of wealth that everyone's been talking about for many years. So this is a given for all clients. However, the regulatory concern with this issue means this is our issue to deal with, and we have to take it seriously. So, and this is my point, consider the importance of transitioning of this to your business and transitioning it to the next generation of clients. And think about this as a case study, this example. You have a client, they're becoming less and less able to deal with their financial matters. They're not incompetent, but they want to sign over and get their power of attorney active in managing their affairs. They're still completely competent. Power of attorney is a child, one of the children. Power of attorney gets a hold of your account statements and says, my parent, my dad, my mother, they would have never invested in this. And here's the importance of having notes on file so that you can defend your position when it comes to addressing these types of concerns from a power of attorney. And this is something that I've heard many, many times, which is, I have a friend, I'm the child, I'm the power of attorney. I have a friend who's a broker, and I'm going to show them these statements. And I have shown them these statements, and lo and behold, they think what you've purchased is absolutely not suitable at all. So what do you do then? Well, you're going to go back to your client account file. You're going to dig up all of those notes that you took when you had conversations with your clients from maybe 10 years ago. And it's going to explain the conversation that you had and justify the decisions that were made. That is the reason why you need to keep good notes. Next slide, please. So here's the reference to what's coming. This is from the Canadian Securities Administrators. This is what I was referencing in terms of the changes to 31103. We expect these to be enforced at the end of the year, we think. And really just one line, proposed amendments enhance investor protection by addressing issues of financial exploitation and diminished capacity of older and vulnerable clients. That's what we've been talking about. Next slide, please. I think we're going to get into, we've got a discussion here. So these requirements really are imposing, we have to now take, or it's going to be enforced at the end of the year, take reasonable steps to obtain information on a trusted contact person. That's number one. And number two, these changes introduce the concept of temporary holds or safe harbor, that sometimes they're referred to, which balance client autonomy and investor protection and support both parties when there is a reasonable belief that financial exploitation is occurring or the client may have become mentally unwell. And these are pure investor protection tools. Again, some of these concepts may not be novel to you. Next slide, please. So who and what is a trusted contact person? Well, it's gathered as part of the know your client information. So that should signal to us, should telegraph to us how important this information is and what it tells us. It tells us that the regulator is telling us to pay attention, time horizon, investment objectives. We want to know if the client has a trusted contact person. Generally speaking, this is going to be someone that the client obviously trusts. They're going to be over the age of 18 or 19, depending on your jurisdiction. They're going to be of the age of majority. And what's it for? Well, the trusted contact person is going to be someone that you can contact in specific situations regarding your concerns about financial exploitation, concerns about capacity, concerns about the power of attorney, and concerns about the client contact information. So it's kind of like an escape valve. It's a relief mechanism to say, look, you've detected some changes. What do I do now? I'm a little worried about the client. You know what? I'm going to call the trusted contact person. Next slide, please. So one of the things that the proposals speak of is that we have to take reasonable steps to gather this information. Doesn't apply to non-individual clients. Obviously, it should not be the power of attorney, and obviously, it should not be you as the registrant. It does not replace the power of attorney. That's number one. And there's no authority to transact on the account. So they can't give instructions to you to buy or sell or transfer money or what have you. And that is often what a client will be most concerned about. Why do you want a name? What are they going to be able to do? Well, they're going to be able to do very little, but I'm going to be able to call them if I'm concerned about you, if I think that you're being exploited, if I think you're unwell, and so on. And the concept will also identify the terms and conditions upon when this type of information, when this person can be contacted. Next slide, please. You can still open the account if the client refuses to provide you with this information, but you should document that. And before you contact the trusted contact person, always a good idea to contact the client first if they're able to be contacted, if you can have a conversation with them. You should advise, the client should advise their trusted contact person, no different than their power of attorney, no different than their executor, that they've been named as such. And this does not obviously stop you from contacting other individuals like the public guardian, local law enforcement, if the trusted contact person is part of this problem. And obviously, as I've said before, we document everything. Next slide, please. So now we're talking about temporary holds. So, like a trusted contact person, this is a relief mechanism. This is, in case of emergency, break glass type of measure. Pause. I want us to stop and think about what would we do in the absence of this provision. Right now, if we didn't have this in front of us, what would we do? If you came across a situation where you were concerned about a particular transaction that you were receiving from a client, what would you do? And odds are, I think most of us would say, well, I would probably tap the brakes. I would probably, if I was concerned, I would probably go talk to somebody. I would call my compliance department, my branch manager, and say, look, I'm not getting a good feeling about this. What do we do? And remember when we talked about informed consent? If you are under the belief that a client is not capable of giving you instructions, I think you're well within your rights to at least take a breather here and ask someone for what you should or shouldn't do, especially if it involves a significant portion of their account, or if they're talking about transferring a large sum of money out of their account. And really, the choice is this: facilitate or freeze. And we have to consider the ramifications of both. I'm always one to fall back on if the worst of it is that I can say to the client or a power of attorney or beneficiary as well. The bad news, the good news is your money is still there. I didn't listen to you and your money is still there. That's not a terrible outcome, because once the money is gone and it's left the account or it's been traded, and unfortunately the trade didn't go as planned, it's a different conversation. Next slide, please. So here is just a slide that I wanted to include. There's information about from the companion policy here that I've highlighted what the what the regulators are thinking. We're not going to go over it, but the highlighted portions are what should be reviewed. Next slide, please. And so really, what is this? What is our hold, our temporary hold, safe harbor? It allows a freeze on the account. It allows us to take a breather, as I've said, tap the brakes. It's based on our reasonable belief. So we really do have to think about this and have a reasonable belief to conclude that there's a concern. And it applies in very limited circumstances: financial exploitation of a vulnerable client that has occurred or is occurring, or if you believe the client doesn't have mental capacity to make these financial decisions. Now, we can't use this, unfortunately, if we think the trade is unsuitable. That's number one. There's other mechanisms to deal with that, or where if we don't do this transaction, the client is threatening to leave the firm. We can't use that to our benefit in those cases. Okay, next slide, please. Right. And here's the other case study that I think I wanted to bring forward. So we have a client, they call in, they've decided to change gears and pursue a very risky hedging strategy involving leveraged and inverse exchange traded funds. This is considered to be suitable based on the information that they've given you. And when you inquire, when you say, "Hey, what's going on, client? We've never talked about this before. Why do you want to do this?" Client says, "Well, I'm doing it because God told me to pursue this strategy." You happen to know that the client is extremely litigious. So what do you do? Now, next slide, please. I don't know if I included. Right, I didn't. So in that fact pattern, what I didn't tell you was that the client had stopped taking their medication. Without that medication, they had an issue with a mood disorder or being bipolar, and that's what was motivating. That was what was creating this. So again, there you're able to detect the change, that there's a complete divergence in strategy, and it creates that red flag. Start asking the questions. So here are some considerations about what happens if a hold is placed. So you've got to obviously document the decision that you've made, got to provide notice to the clients and reasons. You're going to continue to review the fact pattern until the hold is lifted. And then within 30 days of the hold, either communicate or continue to hold and provide those reasons. And when the hold is terminated, you confirm next steps on the transaction in question. So you're going to be documenting and maintaining the narrative. You're going to escalate this to your compliance and legal department. And of course, you're going to consider notifying the trusted contact person. Next slide, please. So we're getting to the end here. So by protecting your client, you are protecting yourself. And this is going to go back to a well-maintained client file. So we're doing this, we always follow and we achieve compliance to enhance the client relationship, create and endure investor protection, and to maintain the integrity of of capital markets. But we're also doing this to protect ourselves and the client. We're protecting the client from the issues that we've discussed already, but you're protecting yourself from complaints and litigation. And this is really what is expected of you, in particular regarding note taking. And if we think about physicians and dentists, a good chunk of their time is spent papering their file, charting their file. That's because they can't remember all of the details about all of the clients that they have, so they write it down. That's what's expected of us too. This demonstrates to somebody like me or a regulator that you've got a process and you stick to it. And above all, this supports you in the credibility war. When that second generation power of attorney comes to you and says, my father, my mother, they would have never purchased this stuff ever in a million years. If you pull out a note that supports that transaction, you're going to win the credibility war. And next slide. I think this is the last one. And if you are not taking notes, I can assure you that the client is. So these are forms that are published by the CSA that provides a guide to clients to how to take notes when your broker calls. So with that, I think that's our final slide. And we can open it up to questions. I think we came in right about on
that's
time,
perfect, Sean.
Marshall.
Thanks so much. That was great. You covered a lot of territory and a very important topic. So we do have a series of questions. So I'll get right into them. First one: how does vulnerability relate to non-personal entity accounts, like personal holding companies, for example? Would it be just as much a concern for those types of accounts?
Yes, absolutely. Because I think at some point we're going to be dealing with an individual, either an appointed officer who can give you instructions on behalf of a personal holding account, or a law corporation or dental corporation, or whatever type of company that you're dealing with. Odds are that individual will be appointed by the company who probably will know if they're in a vulnerable situation or not. But I suppose it could happen, and no different than you being concerned about an individual client of yours not being competent, or being under undue influence, or being vulnerable. The same considerations would apply. You would be asking yourself, okay, well, Sean has been appointed by the board of directors to give me instructions, and that's the person who can bind the client, the corporation. So everything's been fine. I've had a relationship with Sean. He's the bookkeeper or what have you. And all of a sudden, Sean shows up one day and he just seems a bit off. Well, part of that is knowing who the other individuals are on that non-individual account and contacting them and saying, look, you're the client. The client is my company. Sean is the designate. I'm not sure. Is Sean okay? Is he all right? Because I'm feeling like he isn't, and that's how I would deal with it.
Part two of the question is what about corporations with multiple partners or authorized representatives, wherein one or some of all the partners are considered potentially vulnerable?
It's going to be important for us to go back to our documentation on file and ask who can make decisions, or how many people can make decisions. If we can only take instructions from 3 people who are acting unanimously, obviously there's going to be an issue. If you have concerns about 1 or more individuals not who are exhibiting some of these red flags, again, you're going to go to at some point the underlying owners. Hopefully, those owners are not the same individuals, and you're going to ask them, look, who do I need to speak to about this, because I'm concerned that A, B, or Mr. A, B, or C are not able to instruct me properly.
Great. Okay. Next question: how do you alluded to this earlier, but I'll give the question anyway. How do you know that the POA presented is the latest one and valid?
Well, it's it's the latest one. It's easy by asking. You simply say to the client, "Is this your current power of attorney?" I can speak from experience, meaning my own experience. My current power of attorney is over 20 years old, as is my other testamentary documents. So they're still valid. They're still completely fine to use. We ask the question, is this your current? Give me your current will. Give me your current power of attorney. Validity should not be an issue, provided it's been signed and witnessed appropriately. And this goes to the individual requirements in each jurisdiction, which your compliance or legal department or your policies and procedures manual will guide you on.
Great. Okay. It's a good question. Do you have guidelines for taking good notes?
Well, I usually say that's a very good question. I usually say to individuals that the best note you take is one that you are most comfortable taking. So, what does that mean? Well, it means if you're a registrant who's been in the industry for 30 years and you have comfort taking notes on a coiled notebook or on paper or by hand, then take the notes by hand. Write it in your notebook and date it. I usually put a time. If you're more comfortable with technology, your firm will have a client relationship system that allows you to take notes and store them electronically. Those are automatically date and time stamped. The note that you take, the system that you implement is one that you just need to stick to and be consistent with. I have no problem. And in fact, I take great comfort when chatting with clients and they tell me that they have notebooks, physical notebooks going back 30 years of every conversation that they've ever had with clients. That is an advisor who will be strong in the credibility department because they have a system, they stick to it, it's consistent, and it's been enforced for quite some time. The fact that they may have forgotten to write down a particular transaction is less of a concern because we know that their process is robust and they've been doing it forever. Which of course says do not lose those notebooks ever.
Right. Okay. There's a question about robo-advisors, and I guess more generally about other registrants like order execution only investment representatives. How do they fit into all of this? Are they equally responsible for?
That's actually a very good question. Yeah. I think the order execution folks are still going to go through an account opening process, right. And I think they're still going to be subject to. They don't have suitability obligations, obviously, right. But they're still going to go through a client discovery process, and they're still going to require certain information. So I think they're going to be. I'm not actually certain if I'm going to say that I think the rules are still going to apply. I'm going to take the easy road and say yes, they still have to be mindful of it. They can't just ignore it, and they're going to have policies and procedures. I haven't actually looked at that particular issue though. I confess.
Okay. How would you document an account when a client does not wish to appoint a trusted contact person?
Exactly as that. I've asked the question and they've refused to give me information, or they don't want to appoint a trusted contact person. It's as simple as that. It's no different than any other time you request information from a client and they try to refuse to give it to you. Just document exactly that. I asked the question and they decided not to give me an answer.
Thank you. Lots of questions here. Well, we still have time. What kind of action can the trusted person do? Any examples of what a trusted contact person can do or can't do?
There's limitations to what they can and can't do. They're going to be contacted in order for as a vehicle or as a conduit through which you can say to them, look, I'm really concerned about this individual. Can you get in touch with their family? Can you find out more information from them or their family to make sure that they're okay? I haven't heard from them, and so on. So they're not allowed to provide instructions to you on the account. We know that. This is sort of a one-way street, meaning the registrant can get in touch with a trusted contact person as a mechanism through which they can express these red flags, these concerns. I think Sean is unwell. Is he okay? Is he still in a personal care home? What is going on? I'm detecting some concerns. So once they have that information, part of their role is going to be to get in touch with the client, check on them, a wellness check, and presumably get back to the advisor or the registrant.
Great. Okay. Can a valid power of attorney change the risk profile relative to the existing KYC?
So the
Or
client,
raise the
yeah,
risk profile, obviously raise the risk
the
profile.
client is still the client. The fact that a power of attorney is managing or providing instructions on the account doesn't change the fact that the underlying KYC is going to be that of the client. If you have a client that's in a personal care home and is in under the care of doctors, I think you're going to have to evaluate what the appropriate KYC is, the investment objectives, and so on, are for that client. The a change in risk profile should not be addressed unless it's in keeping with what is best for the client, and that is not the power of attorney. The power of attorney should not be using the donor, which is the person who donated the power of attorney, or appointed the power of attorney. They should not be using those funds to trade for their personal, or to exercise their desires to trade in the market on someone else's money.
Okay. This is a follow-up on POA. If the POA is being used due to incompetence, how do we know it's the latest OBE?
The latest
I'm
power of
not sure.
attorney.
Yeah.
Well, presumably you've asked the question to the client, is this your current power of attorney? And that's just not a question you ask at account opening. It's a question that you ask routinely throughout your client relationship. Has anything changed? Still, same will, same power of attorney? Great, I've got it on file. So you have to have some ability to assume that the document that you're using is current and valid. Now, if another individual comes forward with a document that postdates the one that you have, then we're going to have a situation where we may have competing interests or competing powers of attorney. And that's at that point, I think this becomes less of a firm issue, a registrant issue, and it becomes more for the compliance department and the law department to say, look, we're not here to decide who has control over this. We've got two competing powers of attorney, dueling powers of attorney, and we're just going to hold tight here while you guys figure this out. And again, this goes to the importance of having ongoing regular contact with your customers to make sure that you have the most current information, and to make sure that you know who your customer is. Why am I just finding out now that you have a fifth child that you've never mentioned before ever? This would have been good to know, because now I don't know. Now that you're not able to speak to me, maybe you're no longer competent, or what have you. Who am I to believe? These are the situations that we want to avoid.
Great, thanks, Sean. If a known client surprisingly writes a check and a large sum is removed from your guidance, right, I guess from your book, and the client will not discuss why, how do we document this?
I think you take the time to have the conversation with the client. If they tell you to go fly a kite and say it's none of your business, and you detect no other changes, if you, okay, well, Sean, he seems to be all there. He's got a little bit of kick in his boot this morning. Then I think there's very little you can do. You can also seek guidance from your law department and saying, look, this guy's about to withdraw $1 million. It's unheard of. He's told me no reason why. And you will do yourself a service by simply being blunt and to the point with the client, saying, look, are you okay? Are you being held hostage here or something? Because I need to know that I can help you. I can stop this. The best we can do is document that conversation, ask the question, document it. There are limits to what we can do.
Yep. Are there plans for trusted contact person to become a required field on the KYC?
I think based on the drafts that we've seen, or the current version of 31103, I think that's going to be the norm. That's going to be expected. Yes.
Yes. Okay. We often face clients who are doing things that are self-destructive or without regard for the consequences, like overspending, borrowing, just poor choices in general. If the safe harbor rules aren't available for us to use when clients are making poor choices without my reliance on capacity, what tools are there for us to assess capacity?
Tools to assess capacity. Well, I think you're going to be asking yourself the questions that you would say every single day. It seems like this client is completely competent. They've given me no reason to believe that they aren't competent. The fact that they're choosing to spend their money, their funds, their way is really, there's limits to what I can do there. I can tell them that it's probably not a good idea to go to the roulette table and put it all on red, but ultimately that's their choice. They can choose to ignore my advice. I'm going to write that down, and ultimately, if it doesn't work out for them, it's going to be very unfortunate for them. But it certainly won't be laid to rest at my feet as being my problem, and that's really the best thing that we can do.
Great. Should advisors take a position to act in a fiduciary capacity regardless of the existing legal requirements in order to protect themselves and the client?
I'm not sure what that means in terms of protecting themselves, and I don't usually try to put labels on conduct. So if you come across a situation where you are feeling uncomfortable and you have a reasonable belief, that reasonable basis that harm is about to beset the client, I personally I would be very happy to hear that a registrant was taking steps to protect the client. Now, obviously, they're not going to do that on their own volition. They're going to contact the law department. They're going to contact the legal department. They're going to explain the basis for their concerns. But I think these rules empower us, less so on the trusted contact person, more so on the safe harbor or the temporary hold. These rules empower us to feel more comfortable in doing that, to being able to exert some influence over a potential transaction that might be very harmful, or a situation that might be very harmful. And again, the worst case scenario is that the money is still there, the funds are still in the account. And you think about clients that have worked very hard. They have established an account for one of their children when they were a minor. The child becomes of the age of majority. The child is a known substance abuser. What do they do then? These are the issues that I think are going to start, if they haven't started happening already, they are going to be ones that we have to deal with, and we have to be prepared to deal with that. And in some instances, oftentimes, if the client is competent, there can be situations where there's very little we can do. And as I say on multiple occasions, free will and free choice is a very, very, very tough thing to deal with at some point, because sometimes we can't save clients from themselves.
Right. It's a question related to the discretionary manager position. As a discretionary manager, what should I do if I believe I have a client that is incapacitated? Do I continue to operate the account as I have, or should I make changes to how I am managing the investments?
I think it's no different. I think if there's a concern that's detected, a red flag that's detected, I'd be reaching out to see if we have documentation on file that's either appoints a power of attorney or an individual that you can relay these concerns to, and then evaluate whether or not the client's situation has changed such that you're going to need to make changes to how you're managing those funds. It's no different than when a client passes away. If a client passes away, the account becomes an estate account. At least it does in the IROC world. I believe it does in the PM world as well. And it's a moment in time where we have to consider, okay, well, this is now an estate account. This is now an account that's being managed by a power of attorney. Do things need to change? Well, I'm going to be making a lot of payouts. The executor is going to be instructing me to liquidate funds. So perhaps, yes, I should be exiting some positions in the marketplace in order to fund certain liquidity needs. On the other hand, if the client has become incapacitated, but yet the current investment objectives are still valid, let's say the client has COVID and they're in a medically induced coma for 6 months and they're 26 years old. I'm not certain anything has changed, but the point is, I think you need to have a conversation to establish that and obviously document it.
Great. We got 2 more questions, which I guess we could squeeze in. We'll go maybe a minute or 2 over time. If a client has decided to let their child take over all the investments, and the decisions the child makes are riskier than the advisor would ever suggest, the advisor then calls the client to inform them. Should the advisor call the client to inform them about the risk? And if the client says okay, is that enough to protect the advisor?
My assumption here in that question is that there's a power of attorney in play, that the client has not just said, I'm giving my child a trading authorization here. So I would be insisting on the decision making to be done by the power of attorney, regardless of whether a power of attorney is in place. If the client is still competent, you should still be calling them. You're obviously going to be documenting everything, and you're going to be assessing whether or not the client is competent. If the underlying client is competent and is capable of understanding, yeah, look, your kid is going to blow this account up. I'll put it in language that we've all heard before. You're out of your mind. Like, what are you doing? This is not what we have talked about for the last 20 years. And now Junior here is going to destroy your life savings. Do you understand what's going on here? Because they're betting they're going to do they're going to short Tesla. Is that what you really think we should do here? If you're thinking the transaction isn't suitable, there's also other ways for you to deal with this, which is to point out very obviously and bluntly that this is going to happen, that you could blow it all up, and that the only people who are going to be responsible are the client and their kid. And I'd be putting that to them in very uncertain terms.
Okay. Well, one more question snuck in here, so if it's okay, we'll do two more. One's a quick one here. If the POA is not capable of providing instructions and you are concerned, what steps should you take?
Check the POA for an alternate POA. I think, Marshall, is it the POA is incompetent themselves or not skilled? I'd be asking to see if there's an alternate in place, if that's the issue.
Yep. Okay. And finally, if there is a subsequent market loss in the account due to a temporary hold, which is ultimately lifted, is the firm or advisor responsible for that loss once the funds are liquidated?
If there's a loss because there's a hold, I'm not certain I'm understanding that question. It's going to be a question. It's going to be a question of fact for sure. Are they saying if we've placed a hold on a security or on a transaction because they want to sell, and then it goes down? Is that it?
Right. That could be one scenario, or you put a hold on a security that's eventually goes up and you didn't buy it.
That's right.
Yeah,
I think it's a question.
Way.
I think it's a question of fact, and obviously the temporary hold has to be. There's very specific facts for or uses for a temporary hold, and you have to make sure that those are in place before a temporary hold is applied to the account.
Okay. Great. All right. That's lots of questions. Thank you so much, Sean. Great, crisp and concise replies. And so this concludes our event. Thank you so much, Sean, for your insights into the protection of aging and vulnerable clients. And thanks everyone for attending. If you have additional questions, please email us at designations@csi.ca. And a replay of this event will be made available in the coming days on the CSI Resources Hub. So thank you for attending and have a great day, everyone.
Thank you very much.